I brought up this New Jersey land use laws and government ethics pertaining to Quinton Township past and future meetings. This is in reference to my time as being chair over the last few years, minus this current year, obviously. There's a couple things I wanted to bring up, and this is not to disrespect anybody or anything. This is to bring some rules together, okay? As everybody knows, we're going to have most likely a new person in here next year, and that's fine. I mean, I'm all for everybody, but I'm just going to show my outline. This I actually have written down is Jim, Joe, and Marge. 2 of the 3 will be sitting here in January. Awesome. There's two committee members here. Here I have good chance Joe will be back. The thing I want to bring up is we've had a lot of arguments over the last 4-ish years. And I just want to say that we run a government official meeting here. And we've had a lot of not so nice conversations here. I do want to say that it's not a secret. Joe Hannigan was one who had no problem yelling and cussing at everybody here.
Can I stop you for a minute, John?
Sure.
Being that there's a name brought up, does the board feel that maybe we should postpone this and give the name of the person that you stated?
Can I have just one thing to that?
Sure.
I'm not trying to wait until January to do this, okay? I don't want, I'm just being honest, most likely it's gonna be Jim Smith and Joe Hannigan sitting here. I don't have a problem with that. I just have a problem with how the meetings work through. Like, I don't like coming in here and saying that I'm worried about being yelled at over something, a paperclip being misplaced. And I don't wanna wait until January and start off everything on a, I'm gonna do actually what Jim Smith said in one of his posts and say, we're gonna start the new year off right, right and new. Well, I'd rather take care of this now and not just wait and just keep pushing everything through.
Well, what I get at is that, Bill, why don't you,
why don't we,
address this? I think that, would be much better.
well, I think it's important for John to go through his whole list before I start weighing in on anything. I mean, I think that you've expressed your concern about mentioning the name of someone who's not here to respond. But I presume John can proceed with, the list that you have here and just tell the board about, the rest of the things that are of concern.
But, well, I mean, since I've been on this board since 2019, you've greatly expressed, Bill, about the rules and how the rules are supposed to be applied. And one of the things I have here is, and like I said, I'm not trying to go against, this is more about setting rules in a straight line. And it says the next point I have is voting against the master plan. I'm not saying this is about the warehouse or anything, but this is more about, we made a plan and then we just do whatever we feel like it later. So that's just what I'm bringing that up to. Like basically, the master plan is very important. And I don't think that with discussions over the last quite a few years, it doesn't seem like anybody took it seriously. At least not for this town, honestly. Another point is conflicts of interest. This is a small town. There's a lot of people dealing with a lot. It's kind of like saying, for the conflicts, what if Bud's Market were to expand? Every single person here in Quinton goes to Bud's Market. Where do conflicts start? Where do conflicts end? How far do they carry over? Because we've had discussions of, oh, you can't do this, you can't do that, and I just don't like, we just wait until the last minute to figure things out. Like, kind of, what should we follow? And the big one I want to bring up is, like with, where Cody brought up during a meeting, the Sparta judge ruling Facebook groups. You know, there's a lot of things that go into play of everyday life that affect decisions that are made here in front of the planning board. And then I have a rule of picking and choosing which rules to go by and when. And this is just 2 points. This is not saying I'm picking on anybody, but Larry Winkles asked for 20 days minimum to review the warehouse applications, which is great. That was a lot of information. But then at another time, it was stated, we only get 6 hours to review a warehouse ordinance changes. I'm just trying to set one set of rules, or is it a minor thing that we get, 3 days on, or is it a major thing we get 20 days on? Not everybody, if say people, we get our packets on 7 days ahead of time, some people pick it up 7 days and then they don't get the extra information, for everything moving forward. But this also affects the applicant itself. So if, for example, if a lawyer gets tied up for whatever, they get sick, and information doesn't get sent until, like, we decide 7 days before, that's when we need to have the information. But say somebody gets sick and we don't get the information for 5 days, is that the applicant's fault? Is it, do we let that slide? We live by a certain set of rules, but we also live in a small town.
Do you want me to talk to some of those points, or
Yeah,
continue?
that was the list.
Okay. On the part that you just mentioned, the board really is supposed to function as a board in terms of determining how it processes the materials that it receives, all right? And I'm looking forward to future applications here, and I can't get involved in discussions of whatever happened with the warehouse application. That would be, we can talk about that. Typically, there's a requirement for everything to be on file 10 days prior to a hearing on an application. Normally, by the time an application is scheduled for hearing, there has been a complete filing and a completeness review and a determination that the matter can proceed. Once an application gets going, sometimes things are submitted shortly before a continued hearing. And if the board ever feels that it's received something and it hasn't had time to consider it, or it needs more time to consider it, the board can ask the applicant to consent for whatever time periods are necessary for the board to further continue an application. So the board's in control, and by that I mean really what a majority of the board decides. So suppose you have a hearing that's complicated and it's gone really, really late into the evening. It's like 11 o'clock. And all of the testimony's been presented. Everything that's been put before the board can be discussed by the public has been put before the board and discussed. But everybody's frazzled, and there's a lot to think about. In my opinion, under circumstances like that, a board member could say, look, everybody, for my part, I'm feeling like I need some time to think about all this stuff that we've heard tonight. And I just think we need to process it a bit and continue the application so we can come back fresh after having thought about it and make a decision at our next meeting. The board's attorney would ask about the deadline for decision. As you know, there's a time clock ticking on applications where they have to be decided. And if time remains within the decision period, certainly the board, if others agree with what that member has said, the board can vote to continue the application, carry forward the notice by announcement, think about all that stuff, maybe review the materials further, each board member on their own, not talk about it among themselves, and get ready to render an opinion or a decision at the next meeting. That's an example of someone wanting more time. Now, in terms of your examples, well, I'm not going to get into the one about the past warehouse application, but if the board receives any materials, like for example about the warehouse ordinance recommendation, and a member feels that more time is needed to consider it, that member can speak up and say, does anyone agree with me that we should probably take more time to consider consider this stuff we got 6 hours ago and, delay our action on it. And if there's a consensus on that, there'd be a motion and a vote, and perhaps everybody would just take the additional month. You see, so it's the board functioning as a group that decides how they want to process things more than having some kind of a fixed deadline for having stuff in advance. Because sometimes something's very simple and easy to deal with, sometimes something's very complicated, but it's just important for any board member who feels that more time is needed to ask the question, can we have more time, okay? And if it's an application that's pending, that's when we look at the deadline for decision. If there may be other deadlines. I mean, in the case of a warehouse ordinance recommendation, there could be other pressures, but the board is in charge. And so if the majority of the board wants to wait, then the decision is to wait. If the majority of the board wants to proceed, the decision is to proceed. Is that helpful on that last point? Rather than just hard and fast rules, it's more circumstance-based?
I mean, it's hard to put an exact timeline on something.
Yeah, it is.
But because it's hard, because the township buildings only open certain hours to get the paperwork, or you have to print it out from your computer. Some people don't read documents on their phone, just because of convenience, so it's challenging to get the information sometimes, and then it's depending on the information to research it, to do what you want. It's about making sure everybody has the right amount of time to make the decision without being forced upon. So we make the right decision, because every time we make a decision, that's what it's going to be until that decision gets rethought of again. Whether if it's on the master plan or an ordinance change or an application. And we just want to make sure I want to make sure it's fair for everybody.
I think it's important I think it's important along what you're saying for the board to function effectively. If there's a problem in some people needing paper copies and not having the ability to promptly get paper copies, maybe something needs to be thought about in terms of the way the board handles its materials. I mean, maybe there's a different way that paper copies could be mailed or delivered to board members who need them. I mean, I know for my part, my office is open. If somebody wanted me just to print stuff up, I got a gigantic copier that prints. And, I can't do large format plans, but I can do ledger size, and I can do anything I have on a PDF, and I could print things for people in between too. And this is the first time I'm hearing about this, but I'm just giving an example of how there can be workarounds for those kinds of barriers. Because the board has the ability to determine how it functions, And so you could ask your fellow board members, is anyone else having issues with getting printed out copies of materials in a timely manner? And if not, let's brainstorm about how we could make that happen. Because the key seems to me to be getting the materials earlier rather than, so you don't have to make hard decisions about whether there's enough time to act on them at a meeting, So that's another way that the board could help make sure it functions properly, And again, I keep narrowing this down into specifics, and I'm not trying to get away from maybe the larger concerns you have, but I'm just pointing out that often there is like an administrative way of contending with potential problems, so they don't become bigger problems.
It's just as an example, like the brewery application. There's a lot of thought that needs to go into that, because people brought up music, people brought up what they're going to do, people brought up parking. It's not as simple as saying, hey, we're going to put in a hair salon, or we're going to put in a new cafe in the old Bradway's Market. So it's a lot of things have to be thought of, and it's hard.
Well, I'll be the first to tell you right now that I'm in favor of boards taking the time they need to think about, contemplate, and act properly on complicated matters. So even if things seem like they're rolling along fast and everybody's happy and everybody's ready to take a vote on an application, if you or any other board member feels that the brakes ought to be thrown on, more information might be needed, more questions should be asked, and as I said earlier, more time just to wrap your head around it. Sometimes just a month between two meetings gives you time to really think of further questions you may have, you know? And all a board member needs to do is just say, I'm thinking maybe I need more time for this. Does anyone share that concern? Is it possible to carry this forward? Ask the question, because if you ask the question, you might find that you're really speaking, you're vocalizing something that others are thinking about. You may have a large consensus, and I'm saying you, but I mean one might have. And in the midst of it all, I'm able to start thinking about the procedural stuff I have to worry about, time periods, getting the attorney's consent for, postponing if we're up against the deadline, that kind of thing. And you have the ability always to ask openly about the things that you might want more information about, so that you're not taking anybody's surprise over that next month. Could the applicant provide more information about such and so, or do we need more detail about whatever? When we get to an end of the hearing, and I'm making, it sounds to me like everybody's quiet, it sounds to the chair like everybody's quiet, that's when it seems like it might be time to be making a motion on the application. But it doesn't have to happen that way. When one, as a board member, gets the sense that there's about to be a motion made, the board member can pipe up and say, I'm thinking maybe I need more time on this. I have a couple of questions I want to ask, I have a couple of things I want to think through, I want to review the materials more, can we postpone until next month for a decision on this? And the applicant's attorney might say, that sounds fine, whatever. They don't want to risk a denial. And then the notice can be carried forward by announcement. You have time to think about it, look at more materials, whatever, and then come back. The key, though, is to remember that you shouldn't be talking among yourselves as board members about an application that's pending between meetings. Your conversations with each other should take place only in this room, on the record, during the hearing. So when I'm talking about postponing in order to have time to think about it, I'm talking about each of you individually thinking before you reconvene and act as a group, because all your actions are as the group, all right? Is any of that helpful in terms of making sure that there aren't these kinds of problems?
Oh, yeah, absolutely. It's just, we also have a consideration to take in basically the applicant's price involved in a lot of these things, because we've had applications in front of this board where somebody's asking just to put a garage on, and we don't want to delay them or make them spend more money on more things just because we want to take more time.
Well, in that you may not, see, it's all contextual. It may not be necessary to take a lot of time to decide about a bulk variance for where the garage is going to be set back. And a board member who pipes up and says, I think I need more time to think about this, other board members might say, I don't think we do. And again, it's the majority of the board that causes action to be taken or not taken. Someone, if it becomes, some kind of conflict, one board member wants to delay, the rest don't, somebody will make a motion, and if the motion passes and the application's approved, then it's taken care of. I mean, certainly the municipal land use law doesn't want there to be excessive delay and unnecessary requirements imposed on any application. But the applicant does have the burden of proof, and the board does need to be satisfied as a group in its decision. So again, it's all balancing. Complicated application may require more time, many hearings. A simple one might take 15 minutes at one hearing. So, and that's, again, you hear me talking about completeness review a lot. And it's very important to me that there be a good completeness review, because if there is, more than likely the board, by the time it does actually hear the application on notice to the public, there's a better chance that you have what you need in front of you to make the decision. And you don't wind up having a hearing get started and you realize that something fundamental is missing from it. So I think a good completeness review process, which I believe this board has, is helpful too, to make sure that applicants have a pretty good chance of coming here once for a hearing and giving a decision. Do you want me to talk about conflicts of interest?
Yes, please.
Okay. So conflicts of interest are contextual as well. Under the municipal land use law and the local ethics law, it's really just whether there is a direct or indirect financial or personal reason for being conflicted, okay? So a personal reason would be a family relation or an involvement in a business. An indirect one might be a family member's involvement in the business And the case law repeatedly says that it's looked at on a case-by-case basis. So for any member of this board, if an application comes in and anyone feels that they might have a conflict, you know, just thinking to yourself, you know, I've got a kind of a connection with this applicant. Feel free just to call me, okay, privately, and just talk to me about it in advance, because I can help you determine whether you do have conflicts. In one flat out conflict is the 200-foot proximity. If you're a 200-foot property owner, the courts have just said you have a conflict because you're an interested person. And conflict, again, doesn't necessarily mean a terribly bad thing. It just means being in a position where an objective third party might think that your connection, whatever it may be, will somehow impair your ability to function fairly as a board member. That you might have an influence on you that would take you away from total objectivity on an application. So anybody, in New Jersey, the ethics laws are self-policing too. Each one of us has to decide for ourselves whether what we're thinking about doing or not doing is okay under the ethics law. And so that's why just a one-on-one conversation without having to spill your guts in public is a good way to help determine it. If you and I have a conversation about it, which doesn't have to be a long conversation, a few minutes maybe, I mean really it's usually pretty clear. And usually my advice is, if you're feeling that way, and if you do have a connection, the simple thing is just to step down and let an alternate do the work. You know, that's the clean way to handle it from a practical standpoint. So, but if you do decide you're gonna step down, the law does not require that you make a big thing out of it. You just quietly say, I'm gonna step down from this application, sit in the audience, and it's taken care of. So it's case by case, it's based on the circumstances of each individual situation. And it's best to figure it out in advance, for each board member to figure it out in advance. If a board member feels that another board member might have a conflict, in my opinion, the best way to handle that is for the board member who thinks the other board member to have a conflict is to talk to me, the board attorney, and then I can quietly reach out to the other board member and just say, I've heard that there may be some kind of connection between you and the applicant, and talk about it. And what that does is it keeps it orderly and quiet and private, because the person who may have the conflict might not be thinking about it, but it's really not for the board to decide. You know, it's not a public discussion. Those situations are rare. They have occurred. You know, sometimes somebody will say somebody might have conflict, and I'll make the call. And again, it happens. It just gets worked out in the same manner. But this board does not have jurisdiction over what constitutes an ethics violation. All right. This board just doesn't have that power. You're a land use board. You deal with land use issues. So if there's something that's going on that any one of you thinks constitutes a violation of ethics laws, it doesn't get reported to the board. It gets reported to the local finance board, I think it's called, in Trenton. And they have a set of, they have a little booklet on their website. And there would be a complaint filed, and it is a pretty serious thing. And once they get the complaint by one person against, the other, saying that there's been an ethics violation by a government official, they do an inquiry, they do an investigation to see whether there's anything to it or not. And it takes on a life of its own, okay? If they make a decision on it, it can be appealed to the appellate division. It's kind of a big deal. And I can tell you that in my experience for the applications that I've handled, and for the things I've done with this board, I haven't seen anything that suggests to me that there's something that rises to that level. There may be things going on I don't know about, but members of this board have been pretty good about it, coming to me and talking to me quietly on the phone in advance, and we work it out, or they just step down. They just know they have a conflict and they don't get involved. So in terms of what qualifies as conflict, that's really it. A direct or indirect personal or financial interest in an application that's pending. How far the friends and family or business relationships might go is, again, it's kind of case specific. I mean, if it's really, 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 really distant family relation, maybe it might not work. Maybe it might not be a conflict. But the safe position is always to say, look, I don't want anybody thinking I'm doing something with a conflict, so I'm just gonna step down, let an alder get some exercise. You talked about Sparta. I hadn't heard of Sparta before today in anticipation of this meeting. I looked up Sparta, I found out what Sparta's about. Sparta was an application in Sparta, which is in Sussex County. It involved a controversial warehouse application in this town, in the town of Sparta. And one of the initial problems that had to be dealt with was the fact that a bunch of the board members, I think 5 or 8 of them, were serving as board members on the application, but they also were involved in a Facebook page that was devoted to, and maybe operated by, a group that was in opposition to the warehouse that the application was about. So this judge, as a very preliminary matter, disqualified those members and said, how can you square being an impartial decider on a planning board when here you are participating in, one-sided communications on, against the applicant, really. So that's what the basis was. Right or wrong, that's what the judge decided there. To me, that it seems like sort of a correct ruling, maybe not for the exact right reason. What I say to all of you is, when an application hits the deck around here, don't talk about it with anybody unless you're at a hearing, okay? Unless you're in this room and the tape's running and the application's being decided. Just don't talk about it. It'd be like a judge. A judge who's got a case in front of the judge. The judge shouldn't go down to the coffee shop and just start talking with people about the case. It's kind of it's a thing that should be kept in the courtroom. So that's the way I see Sparta. Just, these board members should not have been on let's call it a partisan, and I don't mean that politically, I just mean that positionally on the application, on this Facebook page, and the judge had a right to be concerned about it. I hope that that's not going on around here, and if it is, again, this board is not the decider on whether or not whatever happened or didn't happen is an ethics violation to go to Trenton. And let's see, what else? Timelines, I think we've covered it here. John, anything that I missed or that you want to talk about more on that item?
No.
Okay. The master plan committee. Okay.
No, again, that's not
That's not an issue
specific.
on
That
it.
is not like, I'm saying the vote shouldn't be this way. I'm putting more seriousness to the master plan itself.
Okay.
I don't exactly know how to word every single thing.
Sure.
To make it exactly the way I want to say, because it's difficult.
It is, it's complicated stuff. The fundamentals on the master plan is that the master plan serves as kind of a mission statement for the municipality for its land use regulations. And there's a requirement in the law that any zoning regulation that's enacted by the governing body has to be substantially consistent with the master plan, has to carry out those purposes. You shouldn't have in a municipality a master plan that says one thing and laws and regulations that direct people to do an entirely different thing. There should be a consistency. And the interesting part about the way New Jersey legislature set this up so long ago is that the planning board's in full control of the master plan, which really does set the stage for the zoning regulations. So even though the planning board doesn't enact the zoning regulations, the planning board has a lot to say about what those regulations should be bringing about. So the master plan should be respected in the ordinance and also in how the ordinance is administered. And whenever you have a variance application, what that is someone who is proposing to deviate from a zoning regulation, okay, whether it's for reasons of bulk setback, bricks and mortar, or whether it's a use that's not permitted in a certain zoning district. And one of the things the courts have said is that in granting any deviation like that, you do have to at least square it somehow with a master plan. You gotta find out how it maybe carries out some of the purposes of the master plan or isn't substantially inconsistent with it. So whenever you're dealing with variances, you're supposed to be cognizant of not just the ordinance that the applicant wants to deviate from, but the master plan purposes behind it. In some cases, a particular use that an applicant has in mind might be consistent with the master plan's objectives, but just something that nobody thought of at the time the master plan or the ordinance was being put together. There's some kinds of, because who can imagine what people come up with? I mean, there's plenty of creative new ideas all the time, and someone might come up with something that's prohibited because it's not specifically permitted in the zoning. But when you think about what it is and what it does, it may actually carry out the purposes in the master plan, but just have been inadvertently or not known about, it omitted from the ordinance, you know?
You mean like landing a reusable rocket in Quinton?
Well, you
like nobody would ever think of that.
You'd have to have something in your master plan that somehow suggests that that's a good idea. And that might be a hard thing, but that's the idea though. I mean, if someone comes in with something that is so far from the kinds of things that are allowed in the master plan, then that's probably a use variance that's gonna be denied, you know, if it really is that out of place. Because a use variance isn't just something that's granted because somebody wants it. A use variance is granted because there's a good reason for it, a special reason to use it out, right? So that's where the master plan comes into play with the zoning. Do you want me to jump to the first bullet point a little bit, or do you wanna?
So I'm in that first bullet point. I'm not the only, I'm bringing this up because I've had other people before bring this up to me. So I'm not afraid of people basically just yelling at me saying that this is ignorant.
Well, let's talk about this generally then. The municipal land use law gives board members, in my reading of it, pretty broad latitude in what they can say, pretty broad latitude in what members of the public can say. I mean, there's really nothing that seriously curtails free speech, okay? Even the rules that govern planning and zoning boards aren't supposed to be super strict like a courtroom. The municipal land use law actually says the rules of evidence don't apply. So a lot of times even though I'm alert to the need to keep things procedurally correct, legally correct, I don't believe that planning boards should run with a strict formality like lawyers in a courtroom, because you're not lawyers in a courtroom. You know, you're volunteers, you're people who have your own areas of specialty, and you're here to uphold your oath. You're here to administer land use regulations in Quinton Township. And so, in my opinion, there can almost be a chilling effect when lawyers get to set it up so that it's so strict and procedural that it puts a chilling effect on the rest of the board. So it's supposed to be kind of free form, right? In terms of how people are treated though, there is an expectation that there be decorum, you know, that people don't feel like they're bullied or don't feel like they're gonna get yelled at. And that applies to board members, applicants, and members of the public. There is some case law that I saw where court said that applicants, and I think they said members of the public too, are entitled to courtesy, which doesn't make my head explode. I mean, it seems like it's a pretty fundamental thing, you know, act courteously. And I think that the administration of land use regulations works best when you do take a professional approach, not acting like judges, but sort of making people respect what you are and what you're doing in the way that people would expect judges to behave. So I was talking to someone earlier about how bad it would be to be sitting watching an appellate division argument, watching the judges at the Supreme Court of the Appellate Division of New Jersey, and seeing them arguing amongst themselves and bickering and getting personal. That would undermine the public's faith in the way government was being administered, or the way that courts are being administered. So one thing you could do, and again, as I said earlier, you're all self-monitoring. You're all in charge of your own ethical compliance. You're all in charge of your own demeanor, because you're free to do as you please, really. I mean, you can't do illegal things, but there's no strict rule about how you should comport yourself. But you may want to opt for a mode of communication and a mode of action that reassures the public that you are functioning at least as a unit, and that you're not just quarreling amongst yourselves and being disrespectful to anybody. And so rather than actually coming together and trying to decide rules and decide who should be told how to behave a certain way or not, it might be better for everybody just to reflect periodically on how you conduct yourselves at planning board meetings. and think about what the public sees when they're there. They wanna know that you all know what you're doing, that things are under control, that you're focused on land use matters and you're not getting into extraneous issues, that you're not distracted by personalities, you're not distracted by politics even. As board members, you're appointed to do the job that you take the oath for, and that's very narrow. I mean, you're here to help guide the master planning, you're here to help review, you're here to review development applications, you're here to make sure that land use runs right in Quinton. And so, when I see controversy, I worry a little bit about that for those reasons, okay? It's not like, oh gosh, everybody's doing something illegal. It's more like, wow, the board is getting distracted from the task at hand. And two, sometimes, like the public will ask questions that honestly they want answers to, but they just aren't really germane to land use, you know? They can be distracted, they can be provocative. You don't have to engage when, you don't have to engage at all, but you don't have to engage when it's something that takes you away from your role as a member of the planning board. And you really are just a member of the planning board. This group acts as one, all right? So it's not just a bunch of voices shouting out opinions and feelings. You take in all the information, you review all the evidence, talk about land use applications now, and then you process it, you think about it, you apply the law to it, and you make a decision. And that's it. Shouldn't be a whole lot of passion. It should be done in a very measured way, in an orderly way. So, for your point one, I would hope that all board members just periodically reflect on what their oath is about, what their job is on this board, what the public expects of them, and just do it. Do the job. Keep business-like, you know? I don't know, is that helpful?
Well, I'm, half of this is actually me bringing it up for other people, so I'm.
That's why I'm saying all this stuff too.
Okay.
It's just because I want this to be an opportunity. I mean, here I am doing all the talking, but I'm kind of sharing my ideas about how I think the board can function really well.
Well, that's the thing, moving forward, everything needs to be done in the opinion for the town.
Yeah, everything that the board members do should be, as a planning board, in furtherance of the objectives of the master plan and the ordinance. Okay? If there is something out there that the ordinance doesn't properly address, that's when the board can start looking at its master plan, or looking at recommending ordinance revisions, the kind of stuff you've been doing recently. That's the role that you have in response to those concerns. But this is very different from a political body like the governing body, where you have a constituency to satisfy. Your role really is to comply with the municipal land use law. That's what it's about. It doesn't really get much broader than that. And the ethics laws, obviously, but again, I think the ethics laws are, you're a right thinking bunch of people. I think that you shouldn't have any ethics laws problems. And if anybody thinks they do, call me, you know? It doesn't have to be something that the board gets involved in as a group, because the board doesn't have jurisdiction over ethical issues. They should just be avoided.